Good morning.
Good
Very early for you. Thank you so much for joining us. Our next speaker is, our next topic is, we're looking at state and federal anti-retaliation laws and representing physicians who face retaliation for trying to do what is correct, what is proper practice for their patients. And our first and major speaker is Attorney Teresa Barta from California, who is renowned in representing physicians who face these kinds of situations. So, Ms. Barta, please. Wait.
Can I make a few comments?
Yeah, Dr. Patani wants to make a few comments as well.
I'd like to make a few comments before Teresa speaks. Teresa is located in Southern California, and physicians get retaliated against all the time for speaking up, for doing the right thing. And what we're going to talk about a little later is some methodology to help that. But when you get retaliated against, you're going to find yourself on an island by yourself. You're going to be terminated. You're going to be put at the bottom of the call list. You're going to be run out. And in Southern California, and California in general, when somebody calls me about one of these issues, there's only one person to call, and that's our next speaker. She's top of the game, and I want you to listen carefully.
Thank you, Robert, and thank you, Professor Melman. Thank you also for inviting me and having me. And Bob, you went down the path of yesterday. I listened a little bit yesterday, and I was thinking of how discouraging or scary some of these concepts are for these medical students. And my goal today is to encourage you and let you know you have protections out there. So you don't really, it's not the Debbie Downer that I was kind of worried about with the title of retaliation, because it is a scary topic and it does happen. But I have been in this area practicing for 25 years. All my clients are doctors. My typical question I get when I say that is, oh, so do you do malpractice or do you sue the doctors? And I tell people, no, I'm a physician advocate, but people don't understand what that means, because at first they don't understand this concept of retaliation and how does that come about. And second, they don't understand what types of protections are out there. I can see the audience on this. I haven't done one of these Zoom presentations, so thank you for giving me this opportunity to kind of test it out. Can I see a show of hands of what is my makeup in terms of medical students to law students, just so I know kind of how much to focus which way? Can I have maybe law students put your hands up? Okay. So for the law students, I think in the past when I've done these talks, you'll find it interesting because the laws overlap a little bit with employment type of retaliation or employment law. So if you have any type of interest in that, it becomes very interesting because all of the clients are doctors. I have represented doctors in pretty much every specialty, although I say that and then I get a new one. So that's probably not a true statement. It's probably, there's all kinds of specialties out there I still haven't experienced. But let me tell you a little bit about myself so you can see why you should feel comfortable that I know what I'm talking about here. So I have been practicing, I'm a trial attorney for the last 30 years. The last 25 years is when I've gotten into this practice of representing doctors. And it came about because prior to that, I worked for a law firm where we represented and did what's called insurance bad faith. And I worked in the health area. So all of the clients I had were patients, and types of cases are the patient's insurance refused to pay. Typically, one of the reasons is they would claim, and I heard this come up yesterday about medical necessity, we don't have the medical records, or we don't think your care was medically necessary. And sometimes the insurance companies will do that legitimately because they just want to make sure the care was provided. Other times they do it simply because they don't want to pay. And I was involved in a case dealing with At the time, it was considered an experimental treatment, high-dose chemotherapy for breast cancer. And we had to prove medical necessity of that particular treatment. Well, the only way you can prove medical necessity is by way of the physician coming in and testifying. A layperson can't testify about that. The lawyers can't. So we had the doctor. And as I was driving him back and forth to court in LA, we were both from Newport. So we were driving, hour and a half. I drove him up there, and he became progressively more hesitant the longer the case went on. And I asked him, what are you having concerns about the case? What's going on? And he said, no, I'm really concerned about the retaliation, because the insurance company was starting to deny claims to his office. They were starting to put him on what was called a prepayment review and just starting to give him a hard time. And he said, I've been doing this for 30 years and I've never had an issue until I started to help you guys in this case. And so that was my first experience of seeing the flip side of how the doctors are impacted by trying to advocate and stand up for their patients. In California, we have really strong laws that protect the physician, but it's just a matter of knowing about them. Oh, excuse me. Just so you all know, I don't want you to think I'm sitting in warm, sunny Southern California. I had, a family matter come up, and I actually am in Minneapolis, Minnesota. It's probably colder than where you all are. It's 10 degrees out this morning. So my allergies and everything's kind of a mess here. But going back to, one more time.
There's a doctor in the house.
Excuse me, that I had enough tissues there. Okay, so back to what I was talking about. Oh, so what the transition of that particular case and driving and learning about the doctor having these concerns about retaliation caused me to kind of look at all of the other doctors that were working with all of the rest of our patients' cases. And at that time, I started to research the law. I saw it was out there, and I was working for a firm. And then for you lawyers out there, or the potential law, I had been working for a mid-sized plaintiff's firm. But at that point, I went out on my own, started my own practice. So in 2000, I tried the first case in California under one of our retaliation cases, first case tried to a jury, and did very well for the doctor. I'm going to talk about that case in a minute. And just created this niche. And so ever since, that's kind of been my practice. And I love it because I'm helping the doctors, but I'm helping the patients because the doctors are helping the patients. And so I'm just very passionate about this area of law. Let me start with this, because yesterday, again, I was hearing some of the things, and on top of, I'm sure it's just the concept of going out and becoming a doctor, and you're given all of these discouraging things you need to worry about, audits or False Claims Act and liability, and now you're hearing retaliation. Oh my gosh, how is this going to fit? Let me start by asking all of you, please raise your hand if you yourself have never been a patient at any point in your life. And I can see half the room. I'm assuming there are no hands on the other side. So that question is how I pick a jury. And the jurors are sitting there and maybe have a panel of 80 or 100. And I ask them that, and they all look around and no one puts their hand up. But the point really hones in to my client, and more so to the defense, which is either an insurance company, a large health system, a large medical, or even a small medical group. And they look out there and they see that every single one of the jurors is a patient and is going to relate with my client, the doctor. And that's exactly what happens. After my cases, I'm able, after we go through a trial, we're able to talk to the jurors and ask them questions. They ask me questions, and inevitably I always get the following. I had no idea that that's what my doctor was going through. I had no idea when I'd show up and I show up for my 8:30 appointment and my doctor, they say, is already running behind. How can that be? But through the cases, I present the evidence that shows all of the struggles and all of the pressures that you have been hearing about, not just from the bill pay side, but you're going to get pressures to see more patients in shorter periods of time. You're going to get pressures to order specific types of tests or not order specific tests. You're going to get pressures to, I'm just going through in my mind all of my different cases, what's happened. And you always will want to put the patient first. That's why you're in medical school. That's why you're doing what you're doing. The jurors then relate to that. So you have these laws, which I'll briefly touch on because they are California, but we have also researched, and I do know there are very similar laws across the entire United States that protect physicians. And I think there's a later session where I'm going to talk about how to find and get that help should you need it, or how to avoid it if you can. But I think being true to your profession and taking care of your patients first, you should feel very empowered and very encouraged to do that because these laws protect you. So coming back, I kind of want to go back to the jury selection because I just had this happen a couple months ago. And this to me showed me after all this time how powerful that issue is of the relationship of being a patient or knowing patients and the impact it has on the success of a retaliation case. So I represented a neurointerventionalist. That was one of those areas where I thought I had seen it all. And the next thing I know, I have learning all about stroke and comprehensive stroke care centers and the laws that govern transfers of stroke, potential stroke patients. So I represented a neurointerventionalist, and she was just out of her, she just completed fellowship. So she very highly trained, a young woman, and she started to get pressure about being on call at multiple hospitals, which for obvious reasons in stroke care you cannot do. And there's specific California, I'm sure there's federal laws, but we just had a Los Angeles regulation and we had California law. And one of the whistleblower, it's called whistleblower, but it really is just a protection of physicians and healthcare workers. If you refuse to do something that will violate the law and you're retaliated against in any way, you're protected. And so we sued. She refused. She said, I'm not going to be on call at multiple hospitals. One, it's not good patient care. Someone's going to die. Number two, it violates the law. And she ended up on the receiving end of a termination. That one was a pretty extreme reaction. I don't always see terminations happen immediately. Usually there's something leading up where there's more pressure or they try and affect, there's different, less extreme retaliation. It kind of builds usually is what I see. When I get my clients and we sit down, we talk about what's happened to them, they can kind of see it coming, and then there's different ways they can get out of the actual termination. In this case, she was terminated, and then on top of that, the medical group sued her, claiming she had breached her employment agreement. But coming back full circle to the jury selection part, we went through litigation, we did discovery, we got to a jury trial, and we went to pick the jury. Oh, just so you know too, so he and the medical group, it was the owner of the medical group that sued her. The judge dismissed all of his complaints against her before we even got to trial because they weren't legitimate. It was just another form of retaliation, which made my case even stronger because not only had she been terminated, but now she had to deal with, the receiving end of the lawsuit. We got to trial and it took us 2 days to pick a jury. We had an original panel of 100, we got it down to 40. They had to bring in another additional panel. And the main reason was almost every person of that panel, either themselves or they knew someone who had been involved with or had a stroke or symptoms of a stroke or experienced, or they'd heard about a stroke. And so that relationship of everybody knowing about that, it just kept coming through as we questioned the jurors. And as soon as we picked the jury, we picked them late on a Friday, and Monday morning we were supposed to come in and I was supposed to come in and do opening statement, and I show up and the jury was excused because we'd settled the case on Sunday night. That one, that showed to me that, and I could see in my client too, how worried the defendants were, because all those jurors already related to my client and to the fact that she was standing up for her patients. So let me just briefly talk about, and I know the laws in these other states will kind of mirror some of these concepts, but basically there's different types of ways you can stand up that where retaliation is protected against. The main one is any type of advocacy for the patient. And that can be, in California, we have a particular code that is literally drafted specifically for physicians. It says that no person, and person's defined as a corporation, a business, anyone. So no person, no one shall retaliate or penalize a physician or surgeon, it's that specific, for advocating for patient care. And then it does break down advocating into two different branches, which is really important because it protects the doctor. One side is protesting or complaining or standing up against any policies or procedures or anything they feel impairs, again, this is specific language from the statute, impairs the physician's ability to provide adequate or what they believe to be medically necessary or appropriate medical care. So it's really, really broad, and it gives a physician the ability to know, I think this is medically appropriate. Maybe my colleague doesn't, but I do. So I'm going to stand up and I'm going to push or complain, or this policy interferes with that. That type of advocacy falls within that broad scope. But there's a second definition in California under that statute, and it's to appeal denied claims, because a lot of retaliation happens. Well, I personally believe all of the retaliation happens because of profit motive and money. And that's always a big theme in my cases. Either it comes down because of claims and billing, or because the physician is doing something that is costing the insurance company, the health system, the hospital is costing them money, or is impacting their profit or revenues. So this denied claims. So one of the ways of advocating, the California statute says, is when a physician appeals denied claims. And that comes back to, for example, the first case with the doctor that I was working with, where he was going back and forth to court, and the claim for the patient had been denied, and he was standing up for her because we needed his testimony that she was receiving medically necessary care. So he, just that type of situation stood as one of these, I'm appealing denied claims. So sometimes it's assisting, sometimes it's actually writing a letter or having the medical staff write a letter. So yesterday you heard about I kind of was able to, at the tail end, hear some of the stuff about the recovery actions and, prepayment audits and special claims review. And when those things happen, the insurance companies, from my perspective and what I've seen, use those sometimes they're legitimate because the insurance company just needs to know there's a certain unusual treatment or something. But in a lot of circumstances, they use those punitively. And I heard Ms. Macklin yesterday say exactly what I argued to the jurors, and that is it becomes burdensome because the doctor has to take time out of their practice to write an appeal letter or call and do what's called a peer-to-peer. And so they use these, the insurance companies or health systems use these in a way to retaliate. and try to get the doctors to toe the line. And so these statutes that say when you're doing that, when you're appealing denied claims or you're protesting a decision might be a denied claim or a denied, we're not going to cover something, you're protected. Sometimes the doctors don't even know that they're being retaliated. And one of my cases, excuse me, was a psychiatrist, and he was nearing the end of his career. He had left private practice and he wanted to have someone basically, run the management side. So we went to a medical group, pretty large medical group, and he started practicing, and he was excited because he only had like 2 years left and he was going to retire. And he'd been with the medical group for 4 or 5 years. Everything was going fine. And out of the blue, this is what he and his wife, when they came to my office, told me without waiver of the attorney-client privilege. This all came out in trial. So he came and he said, yeah, I get this notice and I'm fired. I have like 2 weeks notice and I'm fired. That's it. He said, I didn't do anything wrong. I never got notice of doing anything wrong. I don't know where this came from. And his wife was like, yeah, I said, what happened to the department with psychiatry? And they said, oh, we outsourced it. And they said it was for financial reasons. It was going to be less expensive for us to outsource it. Okay, long story short, I asked him to bring me every piece of paper that he still has from his medical practice at the group. They bring me this big banker's box, they give it to me, and I start going through it, and I find some memos, and then there's a pattern to the memos that he wasn't really thinking of because he was just doing his job of practicing medicine. And I said, there's memos here, and they get progressively closer and in time and more emphatic, but they told you to stop prescribing certain psychiatric medicines, for his patients. And I said, what did you do when you got this memo? He goes, oh, nothing. I just threw it in the drawer. I said, so you didn't follow what they wanted you to do? Nope. I said, well, then another one came 2 weeks later. What did you do? He said, same thing. I didn't do anything. And then bottom line was, I looked at that. And then when we started to look at the financial explanation of why they say he was terminated, that was pretext. It was something that they came up with. And so that case, and that you can see how they get kind of tricky. It's like, well, that could be a legitimate, we are going to outsource, or it was legitimate. He was refusing to do what they wanted him to do. Well, in that case, we found out they had hired a brand new pharmaceutical medical director whose job was to cut costs. And one of the places he did that was in this area of psychiatry. So very interesting cases that went forward. In my later section today, I'm going to share some fun facts of that case, of again, why and how you can protect yourselves. But that case went through a lengthy pre-trial, but when we got to the jury trial, once again, the jury was very upset with it was a medical group. They were so upset. It was so obvious they were upset. They gave him, it was like over $3 or $4 million, $3.8 million jury verdict. But then what they did, and this is where we could tell they were upset, is in California, when we try a case that has the potential for punitive damages, it's bifurcated, meaning the jury is not asked about the punitive damage portion. They are asked a question of whether or not the defendants acted with malice, oppression, or fraud. And they have to check the box, yes or no to each one of those. If they check the box, yes to any of those, then we do a second phase where the punitive part of it, basically it's just the finances of the defendant are put on. And then the jury hears that, and then they deliberate a second time, and then they come back with a punitive award. In all of my cases, I have always, knock on wood, have had those questions come back with a yes, because the jurors as patients are very upset with the interference of the patient care. In that particular case, and in other cases I've had, we can do what's called polling the jury, and the defendants typically do this. They'll ask each juror, is that your response? So we can find out when we see that, when they answer yes well, they answer yes to some of the malicious malice, oppression, fraud, we can see how many of the jurors thought that. And when you see 10, well, we only need 9 out of 12 for a civil case. But when you see 10, 11, or 12 hands go up, that they almost all of them answered yes, and they all are going to award punitive damages, the case settles before they're asked to give that number, because the defendants, basically I had a case against Anthem, and they were just going to stipulate, they're a publicly traded company, and they were just going to stipulate that their net worth, the number we were going to put in front of the jury, was $2 billion. Well, the argument on punitive damages is you have to make it hurt. You have to make sure it's punitive. So if you let them off and it's a couple $100,000 or it's a couple million, that's not going to hurt. And so I have a particular argument I use for that, and haven't been able to make it yet, because the jurors are very emphatic that you can see what they're going to do and the case is settled. And I share that because that's the empowering part for you as physicians, that you should feel comfortable advocating and standing up for the patients and not worrying about the retaliation side. Sometimes it can be a drawn out process where you have to, go through the whole litigation, and it's costly, but these statutes also provide for recovery of basically the costs and attorney's fees to pursue the case. So again, the retaliation laws are very protective of healthcare workers, of physicians, and it's just you going out and being a strong advocate. The jurors, when I do talk to them, also feel bad, because sometimes, as physicians, you may have the patient come in and they're frustrated. They've been sitting out in the lobby and waiting to see you, or they're at the hospital and there's certain things not going right. I had a case that, again, it's settled in part, so I didn't get to do this, but they were putting pressure on my client it was a large healthcare system. They were putting pressure on my client to see more patients in less time, spread out. The physician was a specialist who followed a certain, and for confidential reasons, I'm not going to go into the details of it, but had a certain medical condition that they followed, where they had to follow the patients over time. And the physician was told, instead of seeing that patient every 2 months, you're going to see them every 6 months. And the physician said, no, I'm going to see them every 2 months, and I need 45 minutes. I'm not going to do a 15-minute. And the bottom line is, there was this concept that came up called lean, which now has become, as I know it, pretty common. And that is, we want a lean organization. It's all about efficiency. And during that case, that concept had just started to come up, and I was able to even depose one of the medical directors. Well, it wasn't a medical director, because those are always physicians. It was the administrator they brought in to implement lean at this organization. And he was so proud. I took a video deposition of him, and I knew I wanted the depo to last 10 minutes, because I was going to play the whole thing for a jury, because I had learned from his background that lean had started in the whole concept. Has anybody heard about this concept? Show of hands or anything yet? So this concept of lean, because a lot of trials are very theatrical. So it's kind of like, how do I keep the jury interested? And I learned lean came about from the Toyota assembly line. It was, how fast can you make a car with the least amount of effort and the least amount of cost? And I was just appalled of, how are you ever going to apply lean in the healthcare system? And throughout discovery, I could see how they came in, and the doctors and healthcare workers and professionals were all told to start fitting this mold. So again, as we started to prepare for trial, and they were very adamant, they were not going to settle the case. This was something they wanted to establish, so all the doctors knew they had to follow and toe the line. But I decided to use, and I wish I could put it up right now. There's a I Love Lucy Candy. She's at the candy assembly line, and the candy's coming down, and her supervisor's telling her to, how you doing? And she's kind of keeping up. She and Ethel are doing their chocolates, and pretty soon they can't keep up. But instead of complaining or telling the supervisor, when the supervisor comes in or the boss comes in, she goes, how's it going? She goes, oh, we're fine, and makes it look like everything's fine. And then what do? They speed up the assembly line even more. And I was like, that is exactly what's happening with these doctors. And I was so excited. Of course, I didn't get to do that because the case settled again. So I guess my message to all of you is, and I haven't really gone down into the weeds too much about what the law is, those specifics. It's more to just let you know that these laws are out there, and they will and do protect you. And it's just the threat sometimes of knowing that you're going to get a jury trial, or these things that they're trying to pressure you to do that they don't really want. There's confidentialities, and that there's a lot of pressure in things that they don't want made public. All of that is really strong leverage for you as physicians to be able to fight back against them. Just in kind of closing, some of the things, and again, I heard Ms. Macklin yesterday, she said, if something doesn't feel right, that's where kind of your gut's going to come in, because some of the retaliation or some of the things where you're trying to figure out, why is this happening? I mean, I had a client, and he appealed. This was the classic. He appealed a denied claim. And I told him to, and this one, he actually wrote a book about this case. This case went on for about 7 or 8 years. We went up to the Supreme Court. We were over in Florida in the Southern District. It involved Anthem Blue Cross, and they were part of a huge class action settlement. So the case took on kind of a weird turn, but it all started because he took Blue Cross to small claims court over a $700 bill. So he stood up for one of his patients, and he said, I don't need the 700. That's not the point. But the point is that the care needs to be paid for. And so by standing up to him, he started basically a small war, and he was very aggressive about it. So that's why I think the case went on, and it took a whole nother life. And again, if you pull up, I think he sells it on Amazon. It's called Denied. It's the whole saga. But he had one of those experiences where I saw almost the whole realm of every type of retaliation and how it escalated. So at first it started where he would get calls when he ordered, he was an urgent care, emergency type doctor. And someone would come in and they were in a car accident, and he ordered an X-ray or an MRI, but he had to talk to the medical director of Blue Cross first to justify it. Then so there were these efforts of making him go through more and more hoops just to get something paid. Then that didn't work. He didn't back down. Next thing you know, they started to deny claims for him. Then it was on prepayment review. That case was really obvious why and what had happened. But as in the other case where I had the psychiatrist who couldn't really put his finger on what had happened or why he had triggered it, he just knew it just didn't seem right that all of a sudden he was fired over this outsourcing. So later today, or I think in just about an hour, I'll be going through how to get help and how do you find the help if you end up in one of these situations. So I'm going to share my thoughts on that in a little bit, but I think I've covered everything I wanted to cover, but unless anyone has any questions.
Thank you very much. Couple of things. So I have some further information about state laws, which I was going to tell you about now. But since we're at the break time, what I propose to do is to postpone that, and then when we resume, spend just a few minutes giving an overview of the state laws that exist, and then we'll turn it over to Dr. Bertani to talk about unions and medical necessity. So let's just take some questions for Ms. Barta. Anybody have a question? Yes, there's one over here.
Thank you, Attorney Barta, for that very nice presentation. It's nice to hear from people who are on our side once in a while. but you made us very envious when we look out your window and we see those beautiful palm trees out there.
Oh, well, I'm in a hotel room and I was trying to figure out if that's so funny. I was gonna actually try and take those off the wall because I couldn't, it's in the hotel room. I don't even know, it's some abstract art. I literally am sitting in a hotel in Minneapolis. So don't be jealous. It's only 12 degrees here.
Anybody else have any questions? Anybody online?
Yeah, I have one Zoom question.
Okay, and then we have some more here, but go ahead.
Okay. Have you had any cases against a private equity group or similar entity, or are they protected by their status as not being the direct employer?
They are not protected. The statutes, literally both statutes in California, the one whistleblower is against the facility or any of the medical group, but it also has, or any entity that owns or is an operator or manager or has any ownership interest. So, and the other statute I mentioned where it says any person, and person is defined as any entity. So it runs the whole gamut. I've not sued a private equity group because I think they typically tend to sit in the back seat and have all the dirty work done by the guys up front. And that's usually, in terms of going down a lawsuit, I try to be pretty streamlined and focused on who the jury's going to find liable.
I have a couple of questions from the audience.
Good morning.
Good
So my
morning.
question was, like you said, most of your anti-retaliation cases ended up settled. And in class, we were talking about how when they're settled, mostly you have to sign NDAs and then you're not allowed to talk about these things and the details of the case and why the physician was retaliated against. And we were talking about possibly making these things public record and eliminating this signing of NDAs. In your experience, do you see this happening? How feasible is this?
I think the NDAs are very problematic, the confidentialities that they require. And that's why I'd been asked, it's like, where are my cases? Can you find them online? Can you see? I said, no, first of all, I have not established yet any real appellate laws or case and big, verdicts, because they get scared and they settle. And then when they settle, they don't want it known. What I'm very adamant about, though, in the settlements with my clients, and because I have a lot of leverage at that point, I will only agree to confidentiality as to the amount of money that was paid. So in the settlement agreements that I enter into or have my clients enter into, they're still allowed to talk about what happened to them, how the lawsuit unfolded. In fact, as I said, my one client has written a book. I've written a book. I did hide the names. I changed the names, but I've written a book about them so those facts can come out. And I also then am able to use those in other lawsuits that follow. So for example, if Blue Cross engaged in a certain practice and it happened against multiple doctors, I can use what happened previously in the later ones. But if there's a way, like in the Me Too movement got rid of that NDA disclosures or prohibition in discrimination and harassment cases, if we could do that, I think it would be very empowering, because more of these would have more publicity. It's just, honestly, I think what the problem is, I don't worry because I'm in this business of filing lawsuits and being in litigation. But once a physician goes through the whole lawsuit, they get a settlement, they kind of want to move on and they don't want to breach that. So they're very scared of saying or doing anything, even though I try to give them a lot of free rein that they could talk about what happened.
Perfect. Thank you.
Other questions? Yes. There's one here.
Yes, thank you for speaking today. This has been really insightful for me, especially I'm a medical student, so I know nothing about law. I can confidently say zero. So
That's okay. And just so you know, when my clients, when they come to me, they typically, they walk in and they'll say, I don't really want to know what's going to happen in all of this. Just help me, protect me, and let me know when I need to be bothered with the case. Because, and it is, you know who it is? It's the doctors who put their patients first. And that's what they're worried about, are the ones that typically kind of run into these problems. But you don't have to know anything about law to still have it help you.
Great. Well, that's good. So I have maybe a more basic question, but so I have heard a lot from physicians and from my own mentors of like issues that they have with getting patient, like doing the best they can for patient care with barriers like insurance and like private equity and like their employers and big hospital systems. And I've heard that over and over again. And even when I was deciding to go to med school, I'd ask doctors like, what do you like and what do you dislike about the job? And it was usually like, well, what I dislike is when I can't give chemo or when I can't give XYZ or can't do whatever. But hardly anyone, if any physician I've ever talked to has taken legal action for certain things. And I'm wondering, can you speak to like the barriers for that? Like, I imagine it's a big time cost, physical money, like monetary costs, emotional costs. Like, what barriers do physicians have for taking that action? And then what do you do to empower them?
Thank you. That is a great question, because that's one of the reasons why I was excited to be part of this program. I think the biggest barrier is physicians just not knowing what their rights are and not understanding how strong and powerful they actually, just one doctor can stand up against. I mean, and I right now have a case United Healthcare. That case, I can tell you right now, is not going to see the light of any jury. Just, you know, there was on the news again this morning about the Luigi, whatever his last name is. I mean, these cases settle, and these cases then, as part of the settlement, I allow, and what I do is I put in there that there's a prohibition that the medical group or insurance company, they can't engage in this practice anymore. And it sounds kind of like onerous, like how does that work? I'm kind of getting sidetracked from your question. I think the biggest barrier really is that doctors are just, they don't know about these laws, and they're unsure of what will it take if I have to move forward. And then I hate to say this to all you guys, but I've heard my clients say, yeah, sometimes we just, I don't know, we just don't stand up for ourselves. And I was like, I know, because I have also had clients come to me or potential, and they'll say, oh, what do you think of this case? And so I do my cases mostly on a contingency. And what I tell them is, if I'm going to put in the next 2 or 3 years into a case on the risk of not getting paid, you must have a pretty good case. And yet I still have doctors that'll say, well, I don't know, I'm afraid. I'm like, well, they've already retaliated. I don't want to talk someone into a lawsuit, but I think the barrier really isn't the law or the cost, because costs, all of that gets taken care of. You recoup that at the end of the lawsuit. Okay. And a lot of law firms will pay the costs as we go through the lawsuit. So it's not like you're a young doctor and you don't have the extra money. It's like, I do that. And I'll be paying costs of depositions and the filing fees. And in certain cases, the court requires the defendant, if it goes to arbitration, they have to pay those. So it's not costs. It's just, yeah, my clients, they just say, we just don't stand up. I think Robert Batante, if you can see, if he's shaking his head, I think he knows that too. He's always one of those, yeah, they just don't stand up for themselves. So
I have a question. Do you have another question?
I just wanted to say thank you. And yeah, thank you.
So I have a question. So Teresa, you talked about how there are no sort of appellate reported cases, that we can find, so lawyers can't find precedent for these kinds of for the resolutions of the cases that you have successfully represented physicians in. What about, so these laws typically have enforcement provisions for the government to, for example, levy fines or sometimes, revoke certificates of operation. And you can't find any record of any of that happening anywhere in the country either. And I'm just wondering, are we not looking in the right place when we try to find those, or is that also possibly because of the settlements that, it just doesn't ever get to the government's, desk?
I have a little more cynical view of why that governmental doesn't happen, and it's for the same reason I've tried to get certain laws passed and certain things done, but and this will sound discouraging, but I think the insurance and healthcare system or healthcare side of it has such strong lobbyists and their involvement in, at least, and I don't want to make anybody upset up in Sacramento, California, but there are certain people that are put into certain positions that should be taking certain actions. And I don't think that they always do that in the interest of the physicians because the statutes do provide for that. Like both of them I'm talking about have penalty, but that's not something as a civil attorney that I can go through. That has to be brought, and again, then that also comes back to the physicians standing up, and if as a group they come forward. But again, for some reason, and maybe we can get the tide turning here because we have a next generation of physicians coming out, that they become I don't want to use the word unionized, but like a group, like we're all going to agree together that we're all going to stand up and we're not going to allow this new assembly line type of lean Toyota car manufacturing practice.
All right, thank you very much. We'll look forward to your presentation a little bit later this morning. Round of
Thank you, everybody.
We'll now take a break. Let's take it till 11 o'clock, and there should be some refreshments still out there if you'd like them. And then we'll reconvene, and I'll talk a little bit about what states have these laws and what do they look like a bit. And then we'll turn it over to Dr. Batandia.